Hi everyone, good evening. I'm Shivani Nair, and today I'll be taking your lecture regarding divorce deed. What is a divorce deed and how to draft a divorce deed? So, currently, I'll be sharing my screen. Please have a look at it. So, we're gonna cover the topic of divorce deed, and what we're gonna see in this is what are the topics that we're gonna discuss today. First is what is a divorce deed, then the essentials of a divorce deed, important pointers while drafting a divorce deed, a sample divorce deed which I'll be sharing at the end. Now, what is a divorce deed? In the case where the husband and the wife are undergoing a matrimonial dispute, and such matrimonial dispute is irreparable, wherein they have reached to a point where they cannot talk about it, where they cannot, there is no other alternative than separating, then they form a mutual agreement, and such an agreement will be termed as divorce deed. Now, in India, divorce deed has both legal value and a legal effect, so it must be drafted by keeping in mind all the relevant points. Divorce deed depends on the facts in individual case. So the issues between the parties and other related issues, everything is supposed to be mentioned while drafting such a deed. We shall explain in brief some of the important tips and on how to draft a divorce deed. Now I'll be sharing the format with you soon. Now, essentials of a divorce deed or what are the requirements of a divorce deed. So I'll let you know. The divorce deed should contain all the issues pertaining to the details of the parties, the marriage details, the children or stridhan, whatever maintenance they have, what the timelines included, and the methods of separation that they've adopted. So supposedly, like under Hindu Marriage Act, 13B is the section that they would go through when they would be applying for mutual consent divorce. Now, the essentials of a divorce deed, some of the topics that are some of the things that are to be mentioned in the divorce deed are details of the parties, that is the name and their address, then the date of marriage or the registration of the marriage and when the marriage had commenced, then the details of the children, if any, if how many children they have, if they're minor, major, and their status, the status of the children, which includes the custody, who will take the custody of the child, the visitation rights. If the custody is with parent A, then the visitation rights would go to parent B, and for how long, what is the duration, etc. The expenses of the education incurred, the marriage of such a child, who will take all these expenses, and where and who will be responsible for this. Alimony issues between the party, like for instance, it will be mentioned in the deed that they would no longer alimony would be provided or certain amount will be provided until so and so date. Whatever it is will be mentioned within the deed itself. Bifurcation of the mutually held properties, like a lot of couples have joint properties. How will that property will be divided, and how will each property, what is the asset divided, the articles that is given, everything would also be mentioned in the deed. Now, in cases of domestic violence or maintenance under 125, all these issues which are all the courtroom proceedings shall either be withdrawn or the FIRs against one of the parties will be quashed, or if one party has filed for restitution of conjugal rights, that will also be withdrawn, and any other related issues which affects the parties based on the facts and circumstances of the case shall be mentioned. Now, important pointers one has to keep in mind while drafting a divorce deed. Now, the divorce deed should contain all the particulars, which is the name, the address, the age of both the parties, along with their photographs. It should also contain the place and the place of marriage, the place of stay, and the parties, including their matrimony. It should also contain the number of children, if any, with their age or date of birth. Divorce deed should contain the entire details of the property that they both have, like such as joint property or the individual properties which they have under their names, including the movable as well as immovable properties with a clear identification number, the value of the property, whether they have sold it, whether it's pending, whatever the reason is, whatever the details of the property are mentioned, it has to be mentioned in the divorce deed. Then it must contain the mode of distribution of such property, like in how will the assets be divided, who will take the percentage of what assets, and the process for the transfer of the title of such property, whether it's movable property or immovable property, whether you're transferring the shares, stocks, or whether you're transferring a house, everything has to be mentioned in the process of divorce. then it should clearly include the aspect that entire dispute between the party is being settled under the deed, and any claims which was made in the past, such as what I told about maintenance, or in the future, which may arise, will be payable in which are to be paid, is not covered in the, if it is not covered in the divorce deed, then it is not maintainable. Then divorce deed should clearly spell that all proceedings, complaints stand settled until the deed, and no claim, counterclaim, etc., will remain against each other, and any future complaint shall be treated as null and void after the deed, and both the parties shall be at liberty to close the proceedings by filing the copy of the settlement between the parties, which means whatever future disputes which might arise, or whatever past disputes that they had amongst each other, both the husband and the wife will amicably settle it. It should also contain that the wife has received all her stridan, permanent alimony, and any other dues which are there in the marriage, and she is foregoing, or as the case may be, all her claims in the property or maintenance. So, in certain cases, in most of the cases, when a divorce deed is drafted, the wife ceases to receive her alimony. The permanent alimony which is given to her, she ceases to receive it, and since it is a mutual consent divorce, which they are applying for, it will not it will there will be a statement which clearly mentions that this is what I am foregoing. The deed should clearly contain the custody of the minor children and the arrangement made regarding their maintenance. For example, if the custody of the minor child is to the father has to mention it clearly that the custody of the child will go to me, and I will be responsible for taking the maintaining the child until the age of 18 or so, and if she is an unmarried child, until she gets married. It should also contain the date of the period and the place where the proceedings of divorce by mutual consent of the parties would be launched. After this deed, it has to be executed in the court of law. Now that has to be mentioned clearly in the deed, where, when, and where will, in under which court will this deed be executed. It should be drafted on stamp paper of appropriate value as per the local laws, so that it becomes valid and is enforceable to the courts. The agreement should contain signature and or thumb impression of both the parties and should be duly witnessed by two persons to give finality to the said deed. What happens if one party commits a breach of such deed? So now there is a lot of chance that even though both the parties were present along with their lawyers while creating the deed, there might be a chance where one of the parties refuses to adhere to the deed and might commit a breach of such deed. So, to deal with this issue, the High Court of Delhi, in one of the cases where Mithun Radhakrishnan versus Astha Sehdev, had stated that when the proceedings is disposed of by the court on consent terms executed between the parties, the court grants its approval or imprimatur to such consent terms, which is essential to be examined. What is essential to be examined is whether the facts of a particular case given by party is such that the breach of the undertaking has consequence or defiance and disobedience of the court itself. Which means if the deed is so executed in the court of law and such a deed is now breached, then it might call for contempt proceedings, which is also stated in the same judgments para 40, that the division bench has clearly held that the defaulting party can be held liable for civil contempt on the ground of breach of terms and conditions incorporated undertaking to the court or made a party of a consent order or decree. This is, of course, with the rider that the aggrieved party takes a plea that as consequence of the breach, she has been placed in a disadvantageous position or has suffered an irreversible grave prejudice. The court further held that in such an event, the contempt court would also have the jurisdiction to direct restoration of status quo and direct the defaulting party to discharge all the benefits, etc., that have enjoyed right. Then, so Okay, so what was held was that in case of the breach of such a deed, it would amount to contempt by the executing court, which is if the deed is made, and like I said, it has to be executed in the court of law. Now, when such a deed is executed in the court of law, an order would be given in favor of the parties. Now, such an order has to be followed, and if such order is not followed, it would amount to breach of that order or the consent decree which was held. Then, in this case, now the party A, let's assume that the party A was the one that had breached the deed. In such a case, party B will be entitled to have all the benefits, and every benefit that was supposed to be discharged in both the favors. Party B would be having those benefits. In this case, the aggrieved party will be the aggrieved party that takes a plea of the consequence of the breach would be in a very disadvantageous position if the breach is done, because this is what has been mutually and amicably decided, which was not agreed to by one of the parties. In such a case, the party B receives whatever the directions of the court are pertaining to the facts of the case, and depending upon whatever the decree was passed, based on that, the remedies would be given by the court. Now, here is a sample of a divorce deed. This agreement for mutual divorce deed in India is executed on so and so, which is on this day of so and so. You write the date over here, and at the place so and so, between Mr. So and so, from now called the first party, and Mrs. So and so, from now on called the second party. Here you will write the party names, both the husband and the wife. Whereas both the parties married on so and so at so and so, which is the on the date of the marriage, the date on which the marriage was registered, at the place where the marriage was registered. After that, the parties cohabitated at the following places as husband and wife. Now, if such, let's assume that the parties had cohabitated in a different place from the place where they were originally married. They have to mention that this is the place where they had cohabitated after becoming husband and wife. And they have to mention all the places, assuming that they have had a job where they had to travel a lot. All the places have to be mentioned in that. Now, this is a sample deed. So in this, I have not mentioned the child. Let's say there is no child born to the couple under this marriage, or as the case may be. Now, if we were to say that the child is born out of the marriage, then in such a case, the age of the child, whether the child would be a minor or a major, and what are the deeds that the child has to, what are the deeds that one of the parties will have to commit, and the marriage of the child, who will take expenses for the marriage of the child, the education of the child, everything has to be mentioned over here in detail. And whereas after the marriage, owing to the temperamental, we have in this paragraph, we need to mention what are the reasons why the husband and the wife decided to divorce from each other, or decide to form a divorce deed. Whereas the marriage, owing to the temperamental difference of habits, thoughts, and increasing incompatibility, the relationship between the parties deteriorated. And finally, to avoid further deterioration of the relationship, the parties had started living separately since so and so period of time. Now they have to mention, obviously, if someone is cohabitating together, a certain period of time, let's say 6 months period of time is given, since they are supposed to be living separately, and in that duration, that has to be mentioned over here, how long they have been living separately, if they had if they were incompatible with each other. Then in the next paragraph, you write, well, all the efforts that were made by the family and friends to reconcile the relationship, but owing to the differences, it could not be reconciled. Such as, whereas the efforts and attempts were made by friends and relatives for reconciliation and resumption of marital relationship, but it could not be successful due to the ideological difference in temperamental, which has rendered normal married life impractical and impossible. The marriage has broken down irretrievably. Then, in the next paragraph, we have to write the conditions. The conditions based on which the parties have agreed to form a mutual consent divorce, or to or to draft this divorce deed. Whereas the parties have now mutually agreed that this marriage is resolved by a decree of divorce by mutual consent on the following terms and conditions. Here I have given certain terms and conditions. According to this draft, it would be: one, that it is agreed between the parties that the second party has amicably settled all their disputes towards Tridan, dowry, permanent alimony, maintenance, etc., and she is not claiming any more amount against the same, as she had already collected all her belongings and there is no claim in any manner now. It is agreed between the parties that the parties to the divorce deed that they will file a mutual consent petition before the family court at, which is like I stated, you need to execute this deed. For the execution of this deed, you have to mention where you are going to execute this deed. So this divorce petition before the family court at so and so place on the date of signing of the present deed and not later than so and so from the date of divorce deed as mentioned above shall appear before the court to make the statements before the learned court. It is agreed between the parties that both the parties shall not file any suit or complaint against each other, and the family members of each other in future shall withdraw all the complaints proceedings if filed anywhere before the authority in this regard whenever the same comes to the knowledge of the parties besides the cases mentioned above. So basically, what happens is you agree to a certain period of time, you agree to certain rules and regulations, and then you agree to state that all the complaints, first of all, which you had filed, let's say under domestic violence and such, you have withdrawn those complaints. And if you have, let's say, the wife has filed complaint in domestic violence and the husband has filed in restitution of conjugal rights, in such a case, both of them withdraw their own complaints, and without the knowledge, without the knowledge of any of the parties, nothing would be done, and anything mentioned in nothing would be in contravention to what is mentioned in the deed. Then the details of their children, their age, and the aspect of the custody of children. Like I mentioned before, whatever the details of the children are, like let's say one they have two children, one is a minor child which is of 7 years old, and one is a major child which is of 18 years old. Who is going to take care of the marriage of the child? Who is going to take care of the custody of the child? Who is having the visitation rights? Let's say the custody of the minor child of 5 years is with the mother, and who is taking the mother is maintaining the child, but then it is not enough, so they take maintenance from the father. The father has also stated that he would provide a maintenance for the child on so and so amount of rupees. Everything has to be decided and mentioned in this deed over here in this point E. Then the details of the properties and their distribution. Like for instance, party A, the husband has one property, one house, and the wife has one car of her own. The division of the property, the division of the assets as such, everything and the distribution would be mentioned in this deed. Then finally comes, whereas this divorce deed has been executed between the parties with their mutual consent and free will without any pressure, force, coercion, or undue influence from any side. This is because this is a mutual divorce decree, this is a mutual divorce deed, and in this case, no pressure from either side of the parties is to be mentioned. This line has to be very clearly stated. And then at the final stage comes two witnesses, the first party for the first party, and for the second party there will be two witnesses, and both the witnesses will have to then sign. This was the draft of the deed, and this was what divorce deed basically means. Any questions? Does anybody have any questions?
Ma'am, I have a one question. So that is, in the divorce petition, can we claim compensation, or there should be a separate application for that?
Sorry, can you repeat again?
In the divorce deed, can we claim compensation, or there should be a separate application for that?
So basically, under the divorce deed, you are mutually agreeing to it. Let's say, like, we agree that so and so amount of rupees is to be paid for the maintenance of a minor child of so and so rupees. All right. So that is something that we mention within the divorce deed itself. We cannot claim a separate. We cannot claim separate compensation after drafting the divorce deed, because then that will be another matter. In this deed, you have to mention clearly as in how much amount of rupees you're giving. If the property is distributed, let's say you transfer property on my name, all right, I have to pay you so and so amount of rupees so as to amicably settle whatever the division of properties that we had. That is to be mentioned in the divorce deed. Other than that, separately asking for compensation will not be mentioned if the deed is drafted and signed by both the parties and the witnesses. All right.
Ma'am, I have a question.
Yes.
Ma'am, you said there should be two witnesses, so two witnesses from each party, or in total two witnesses.
Okay, so two witnesses from each of the party. Now that depends on case to case. I may have also one witness from my side and one witness for the other side. In general, we have two witnesses from both the parties.
Okay, thank you, ma'am.
Any more questions?
And what would be the jurisdiction to filing the divorce deed?
Sorry.
What would be the jurisdictions?
Jurisdiction, that would be the place which they have to decide amicably. Let's say that party A and party B got married in Ahmedabad, but then they currently reside in Vadodara. So the family court of either Ahmedabad or Vadodara will have the jurisdiction, which they have to decide together amicably. Yes.
Ma'am, in this divorce deed, and we have to mention the list of documents also in this divorce deed.
Yes, whatever you are having, let's say the assets that you have and whatever you have, whatever the division of assets that has taken place, let's say in terms of, I'm talking in terms of property, right? All the documents are to be attached. You make the
Okay.
deed and then you add those documents. All right. All right. Thank you
Ma'am,
so much.
you said
Yes. Sorry.
you said it is applicable only on mutual ground, mutual
Sorry.
consent. So will it be different in case of divorce on fault ground?
Divorce or
Fault ground. It is you said it is applicable only on divorce on mutual consent. So will it be different
your,
in case of fault ground?
can you type it? Your voice is not audible.
Okay.
Yeah. Yeah.
As a couple.
Okay. So divorce deed is enough to live separately, but then you have to execute the divorce deed in the court of law. Merely having a divorce deed will not amount to separation of the couple from their marriage. Okay, the marriage still holds a legal validity. Now, what that divorce deed helps in easing the process that is present, by which you can file for mutual consent divorce in the concerned court, concerned family court. This divorce deed is only and only applicable in case of mutual consent, because then only you're having an agreement to form a divorce. When you have a divorce, when there's any fault, then you don't file for an agreement. In that case, you file a direct petition in front of the court of law for whatever other grounds you have. Over here, this deed is applicable only in case of mutual consent, where both the parties have together decided that no, this marriage is not working out, and so we will have to separate from each other. All right.